Good afternoon, everyone, and thank you for being with us this Friday. My name is Michael French, and I'm the Executive Director for La Plata Economic Development Alliance, and today I'll be sitting in for Bonnie Watson. As most of our meetings, the mute, everybody's coming in on mute, and the chat function is disabled, but you do have the ability to use the Q&A feature at the bottom to ask questions throughout, and we will have a Q&A session at the end of the panels. From an economic development perspective, it looks like we're starting to transition from a response of COVID-19 into a recovery phase. And that means that we've moved from stimulus and relief into an early phase of reopening. Most organizations now are working to understand the forgiveness aspect of this. Just yesterday, the Treasury indicated that they may agree to two bipartisan proposals, one already being a bill that is being presented that would extend the cap of expenses versus payroll from 25% to 50% and potentially extend a period of 8 weeks to 16 to exercise those expenditures. These proposals have not yet been passed, but could be next week, so we'll keep an eye on that. As we make a transition to reopening, we're seeing that a lot of folks are dealing with new variables like managing PPP to forgiveness and operational logistics such as leases and other variables as people look to reopen. First of all, we'd like to thank our sponsors. Next slide, please. Who make this series capable. Thank you very much for everybody that contributes not just their hard work, but any dollars that go into us being able to do this. We have a great agenda today. Next slide, please. A couple of excellent panelists that are from a couple of different law firms in our area. With us is Daniel Gregory from Gregory Golden Landeryu in Durango, Colorado, as well as David Skanga from Hoskins, Farina, and Camp from Grand Junction, Colorado. With that, I'd like to turn it over to Daniel. He will be talking about navigating liabilities and lease agreements. Daniel, thank you for being with us today.
Thank you. Pleasure to be here. Good afternoon to everybody. If we can have the first slide of my presentation, please. What I'm going to talk about is, in particular, force majeure as it affects lease contracts and other contracts. And I'll run through this fairly quickly, but hopefully coherently. Next slide, please. You can see that the legal definition, which I'm not expecting the audience to read through all these with me, but they're there for everybody's edification. Force majeure is an event or an effect that can neither be anticipated nor controlled, especially an unexpected event that prevents someone from doing something that he or she had agreed, i.e. contracted, like in a lease, or officially planned to do. The term includes both acts of nature, floods and hurricane, and acts of people, riots, strikes, and wars. Next slide, please. Now I'm going to show you a couple of legal definitions because in essence, these are all synonymous with what we're talking about. And that is some event that happens which would allow someone to have an excuse to perform their contractual obligations. Contractual obligations including things like making lease payments, going forward with a construction project or anything else that one may contract to do. So force majeure, again, is an unanticipated event caused by nature, God, people, etc. It is related very closely to a defense of impossibility of performance. And you can see the definition there on the screen and how close that is to it. Next slide, please. Impracticability is another way that the law looks at force majeure and impossibility of defense. Now, once again, force majeure, in essence, leads to an impossibility of performance. Impossibility of performance has been defined by the law, as we will see, as really not strict impossibility, but impracticability. Next slide, please. This is a Colorado Supreme Court case from 1969. And let's take a look at this. What it says is, and I'm going to get over here to my other screen for a minute on my, I apologize. There we go. So the Colorado Supreme Court in 1969 recognized impossibility of performance, which again is what force majeure would lead to, as the following. The law recognizes impossibility of performance defense to an action for breach of contract. Impossibility means not only strict impossibility, but impracticability because of extreme and unreasonable difficulty, expense, injury, or loss involved. Impossible, the court held, must be given a practical rather than scientifically exact meaning. Impracticability rather than absolute impossibility is enough. Now, this is an important part. What a court would ask if someone wants to plead force majeure leading to impossibility of performance is not just did your expenses go up, your costs go up, but this is what a court would focus on. The important question is whether an unanticipated circumstance has made performance of the promise, i.e. a promise to pay, a promise to perform, vitally different from what should reasonably have been within the contemplation of both parties when they entered into the contract. If so, the risk should not be fairly thrown upon the promisor. Now, this is important because various force majeure clauses sometimes exclude certain things. I've done a quick survey of tenants in particular asserting force majeure to try and get out of a lease contract. And some of the force majeure clauses that have been reviewed by courts throughout the United States have an exception for financial hardship. In other words, they say, well, if force majeure occurs, you may not need to perform, except to the extent that you want to claim that force majeure is causing you financial hardship, and that is not going to fall within this clause. If you contract to assume such a risk, force majeure is not going to help you. You can see the Colorado Supreme Court here. The exception to the defense of impossibility is applicable where, on interpretation of the contract, the risk of impossibility due to presently unknown facts is clearly assumed by the promisor. So if you have a force majeure clause, one that says in the event of acts of God, floods, strikes, wars, famine, pestilence, disease, etc., you may not have to perform. And it says, except that this does not apply to financial hardship or unknown diseases. If you contracted for something like that, then you're going to have assumed that risk, and the force majeure clause is not going to help you much at all. Next slide, please. All right, I've just thrown up a few cases here as examples. There's one case out of Connecticut. Mere increase in expense does not excuse performance under a force majeure provision unless there exists extreme and unreasonable difficulty, expense, or injury. And I would add to it, unanticipated. And then there's a case out of Louisiana ruling that unforeseen cost increase that excuse performance must be more than merely onerous or expensive. It must be positively unjust to hold the parties bound. Next slide, please. All right, so for a force majeure clause, if in fact you think you may qualify to use that as an excuse to perform an obligation that you have under a lease, i.e. paying rent, or under any other contract, a few important things to keep in mind. First of all, look at the contract and provide the notice required by the contract as soon as reasonably possible. Understand that change in financial condition cannot be an assumed risk under the contract. If the contract says that that is not going to constitute an exception to force majeure, that's what you've contracted for, you're going to be stuck with it. And finally, really what you're going to have to show a force majeure clause as being sufficient to get you out of a contract is the event is an unanticipated event, one that you did not cause, one that causes excessive or unreasonable expense, and one that is in fact directly related to the force majeure. That concludes my presentation. Hopefully I've stayed within my 10 minutes, and I'll be happy to entertain questions at the end of the seminar. Thank you very much.
Thank you, Daniel. Really appreciate that. Again, a reminder, if you have any questions, please do use the Q&A icon at the bottom of your Zoom screen, and you'll be given a Q&A window to type in your questions for either Daniel or David. With that, we'd like to introduce David Scango with Hoskin, Farina, and Camp. David, thank you for being with us today and talking about PPP loans and forgiveness guidelines.
Thanks for having me. The focus of the presentation here is on the certification that was given on applications for PPP loans. If we can go to the first slide. Let's go to the next slide. When PPP loans were applied for, individuals needed to certify what I have in this slide here. They had to certify that the current economic uncertainty made the loan request necessary to support the ongoing operations of the applicant. The application forms came out about April 2nd, and there was no real guidance on what this really meant at that time. So people are saying, well, is there an economic uncertainty that makes my loan request necessary? And people had to look in the future as to what was going on in their business, or maybe what was going on at that time for some businesses, to decide if they could make this certification without any or real guidance being given. Next slide. On April 6th, there was some FAQs that were published by the SBA in consultation with Treasury. And one of the FAQs dealt with an issue of these loan applications, and there was a change in loan applications. There was one published on April 2nd. There was one published thereafter. This question goes to that, but the answer is broader than that. In this answer to this question on, can I use, what loan application should I use? And what they said here was borrowers and lenders may rely on, it's not supposed to be loss, that's a typo. It should be on the laws, it should say, rules and guidance available at the time of the relevant application. And this became important because people are saying, well, then I can rely on what kind of guidance I have at the time I made my certification, not what you may come up with guidance later on. So this question became important because of the answer in the context, though, of the certification that was made during the application process. Next slide. On April 15th, there was a regulations actually adopted, not just FAQs, but a regulation. Interim final rule was adopted by the SBA in consultation with Treasury, and it just mimicked the language in the application on whether there was a necessity for the loan, and it just basically said you had to certify in good faith that, again, current economic uncertainty made the loan necessary to support the ongoing operations of the applicant. So as late as April 15th, that is the guidance that was actually out there for the PPP loans. Next slide. There became a pretty, some controversy throughout the United States on the PPP loans because there was a very large companies who were getting these loans, such as the Los Angeles Lakers, such as Ruth Chris Steakhouse. They got some very large loans, and people were questioning the ability of these large companies to get the loans. So on April 23rd, the SBA issued another FAQ, number 31, which caused a lot of consternation. And this was asking a question as to whether large companies with large sources of liquidity could apply for these loans. And if you look at this, the answer to this, it basically said people have to assess their economic need for the loan. And the first sentence talks about at the time of the loan application. Again, let's go back to the application. At the time of the loan application, what was the business contemplating with regard to what was going to occur with their business? Now, when you go down in this FAQ, the answer here, I've highlighted or put in bold here some important information they had in here. He said they have to make the certification in good faith, taking into account their current business activity and their ability to assess other sources of liquidity sufficient to support ongoing operations that in manner is not detrimental to the business. And so they've introduced the concept of looking at other sources of liquidity, loans, capital contributions, cash. And then the question you realize is for a large company, and they talked about then in the next sentence, a public company, substantial market value, has access to capital markets. It may be difficult for them to make that required certification in good faith. This FAQ directed for large companies made a big, started a lot of concern with a lot of companies. A lot of companies applied for these PPP loans, and the question was, does this FAQ apply to a small business? Do I have a line of credit? Do I have wealthy shareholders who can go ahead and give me sources of liquidity by putting in capital? Next slide. On April 28th, the SBA answered one of the questions. The question was, does that FAQ apply to privately owned companies? And the answer was, does it apply? They said, go back to FAQ 31. So in essence, they're saying, yes, it does apply to businesses owned by private companies with adequate sources of liquidity. Is there investors? Are there lines of credit? Those are the questions that came out. And they also had an FAQ came out on May 3rd that said, we will give you until May 14th to pay back the loan without additional concerns that we would not come after you for an improper certification. But they also said, the SBA said, that we're going to issue some additional guidance before May 14th that will allow for, to give a little bit more guidance on whether you need to pay the loan back or not. So people were looking to see what was going to happen before May 14th. Would there be some additional guidance? What should you do with your loan? Those were the concerns. Next slide. And in fact, the day before May 14th, guidance did come out. There wasn't some interim deadlines of May 7th that was extended to May 14th. But this May 13th guidance came out Wednesday of this week. It should help businesses understand this a little more of where the SBA is coming from. And the SBA, in essence, in this guidance says that if your loan is under $2 million, they will deem that the certification that was made in the application you filed was made in good faith. Now, you still may have to show the necessity of the loan, but for them to say that the certification you made was improper, was not in good faith, that would be difficult for them to show because they're basically deeming that to be a good faith certification. That doesn't mean you don't want to have documentation of the necessity of the loan, but that gives a lot of, should give a lot of comfort to companies that have loans that were less than $2 million. If it's over $2 million loan, they said because of really the practicability of just auditing, because it's going to be hard to audit people under $2 million, that they're going to audit those over $2 million to see whether the required good faith certification was made based on their individual circumstances. But they also gave some help to over $2 million loans by basically saying, we're going to give you notice to repay the loan. And if you repay it, you're fine. So you're not going to have liability such as False Claims Act liability that you may otherwise have, or penalties that you may otherwise be could suffer as a result of a finding that the certification was not made in good faith. So this gave some help to people who have loans over $2 million, because they had come out with guidance earlier or indications earlier they were going to audit them anyway. But this lease says you can avoid False Claims Act liability. So I thought that was helpful to them. Under $2 million, at least now you have a deeming provision that says you're deemed to have made the certification in good faith. Now, what should you do? And if you go to the next slide. this is just kind of a suggested to-do list of what I'm recommending to clients. I think you need to go back to when you made that certification. What was going on with your business conditions that made the loan necessary? And this could just be a memorandum. It could be a memorandum to the officers to come together and put together. And I would be fairly specific. I would list what potential losses or business uncertainties you're looking at. Did I lose a contract as a result of this? Did I incur additional expenses I have to incur as a result of this? What has been, I can only operate a 50% capacity, maybe because of there is some district or other health orders through health departments. Those type of things. I would document that type of thing. If you can focus on the impact on your workforce, how many people or you're not going to be able to work now as a result, that would be important. I would also have a document that discusses the strategy for use of PPP loan funds and how that is going to help out. How is it going to help you out? I would do that. And this issue of liquidity, sources of liquidity. Do you have a line of credit? But if there's a high interest rate on the line of credit and you have to pay it back on demand or quickly, that type of thing, then that is not a great source of liquidity. And if you have diverse shareholders, you have 20 shareholders, and having all of them put in money would be difficult to ever do. That would be important. So I think documenting that would be something to consider. Next slide. I just wanted to note here that late in the day, they issued an FAQ on the 13th, and late in the day that evening, they added another question to that FAQ and an answer that basically extended the deadline if someone was going to pay the loans back, that you had now till May 18th to do that. That is kind of where things are at. I think the guidance that came out on Wednesday should be very helpful to businesses that have PPP loans, should give them some comfort in the loan. And I think adequately documenting, what I'm talking about is necessity of loan. Of course, you're going to want to document how you use the loan. That's kind of a different issue. But the necessity of loan, make sure you have that in documentation. If you can show that it was presented to your directors, that the concerns, then you probably ought to document that, or your shareholders. So, anybody has any questions, I can try to answer them. So thank you very much.
David, thank you very much. Really appreciate it. If for those of you that have not gone out and done a PPP application and you think that you do qualify, what we're hearing from banks is that their queue is empty, and that they have a system to be very expeditious around turning applications around and underwriting loans right now. And there is still federal dollars available. There are federal dollars available from round 2. So please do put in an application if you think you still qualify. If you have any questions for David or Daniel, please go to the Q&A icon and type in your question. Daniel, we did have a question come in, and I'd love for you to answer this live if you could. And I'll read the question briefly. If my commercial lease contract has no clause for or no mention of force majeure, does that resort to a standard default of force majeure terms?
And the answer to that is, if the elements of force majeure that I previously discussed, if those particular elements can actually be proven, then the doctrine of force majeure would apply even if there is no specific force majeure provision in the contract. Most important thing to be aware of is, if there is a specific force majeure provision in the contract, have you accepted some risk that might otherwise have been, you might have otherwise been allowed to avoid because of the doctrine of force majeure. But force majeure is what we call a common law provision that would apply to a contractual obligation, even if there is no express force majeure clause in your contract.
Okay, thank you. Also of note, the FAQ document that David was referencing, we'll make sure and get that out to everybody after this call this afternoon, and keep everybody abreast as to changes or updates in guidance for forgiveness on the PPP, as not all of that has come out just yet. I'd like to draw your attention to next slide, additional resources. So you will be able to download today's presentation at tellyourrightfoundation.org under COVID-19 Resources for Business. There's also a ton of other business resources if you go to choosecolorado.com COVID-19. This is a fantastic site. And if you need assistance, continue to look at your local or regional SBDC resources, including Mary's team in Durango and Nancy's team as well, and Montrose. And please go to your SBDC sites. For other resources related to entrepreneurs and entrepreneurial communities, go to startupcolorado.org or reach out to Taylor Grande. We'll just give it a couple more seconds to see if anybody has any additional questions. Okay, fantastic. Access to the call recording, you can listen to it, and other topics across all 4 regions. Just visit Choose Colorado YouTube channel. And if you have additional questions, don't hesitate to email startupco@colorado.edu. With that, I'd like to thank our panelists.
There may be a question on there, Mike. Do we have a?
Mike, I see that there are 3 more questions, maybe.
Okay, fantastic. Yeah, I didn't see those coming in. Question, and I think this is for David. Any suggestions on PPP for people that are sole proprietors or independent contractors, probably 1099 or 1040C? If they have personal assets and home equity at their disposal, does that disqualify them? I think that's the sentiment of the question.
I think with those, I think you have to focus on the business, not the personal assets. And personal assets, I think, is going to be could be a concern for you. But I think you have to try to focus on what's going on with the business and your ability to, especially if you're hiring people as a sole proprietor, that is going to be, I think, the focus of those of the SBA. And there's some specific regulations that have come out dealing with sole proprietors and the way they're looking at the sole proprietor.
David, I think you might be able to also answer this. Can you comment on what percentages of employees need to be retained and for how long in order for the loan to be forgiven?
I wish I could give you the exact numbers, but I can't recall what those numbers are right now. But there is a specific number of employees, and it doesn't mean that you lose your entire forgiveness, but it's a reduction in the amount of forgiveness, and it's based on a formulaic way you would go about considering that. You got to look at what do your employees what does it look like as of, I think it's the end of June of this year versus the employees that you had in the prior year at that time. And there's a formulaic way they look at it, and it doesn't mean you lose your entire loan, but you have to look at, and I can't remember how the numbers work out, but there is some specific guidance on that. I can get that to you later if I can get it, if you want me to get that something over to you on that.
Excellent. Another question is is there an extension to the 8-week PPP spending deadline now in place? And I don't believe so, but can you verify that for me, David?
There is no extension that I've seen at this time.
Okay, thank you.
Well, one of the issues that come up on that is where you calculate your 8 weeks from. It's supposed to be from the date that the money, you actually get the money, is actually dispersed. But I have found that some documents are dated prior to the date Pearson even received the money. So I think some people are trying to go off the date of the documentation rather than the date they may have gotten the money. But there may be some kind of a discrepancy there. But actually, the FAQ is very clear. It's the date you're supposed to get the money dispersed to you.
Excellent. On the question of the percentage of employees need to be retained and the length of time for that, please do reach out to SBDC for some detail on that. I know that they have details, and I've even seen a calculator out there that they might be able to provide. Okay, looks like I'm looking at questions. I don't see any others coming in. If you do have a question, please get it in. Okay.
Like it looks like we have a couple more coming in from Q&A. Let me know if you can't see those and we can read them.
Yes, I do. Thank you so much. And this question is for Daniel. Do you know if rent paid to a real estate holding company from an operating company with similar ownership can be used as rent and possibly forgivable? I think maybe that is, David, around the PPP.
Sorry, could you repeat that again?
Sure. Do you know if rent paid to a real estate holding company from an operating company with similar ownership can be used as rent and possibly towards forgiveness?
I think if they're two separate companies and it's fair market value rent, I think I didn't see anything that would prohibit the payment of rent being considered with forgiveness.
Okay, thank you. If one of our panelists would answer the question, and then maybe we can include this here and call it out, is there a website that will give more details on PPP for independent contractors?
The best website that I have seen has been the actual interim regulation that they've adopted, and they've adopted some of those regulations in question format, so it makes it easier to look at. But that's where I would start.
Okay. And there was a question: is if we could get a link out to that. That calculation in terms of employee retention and time frame, and yes, we'll get a link out to that as well, or a resource to that. Another question that just came in: we've received a PPP loan in our account on April 20th. We've brought back our employees May 1st. Will we be able to use 75% by June 20th? We will be able to use 75% by June 20th. Do I have to go back to April 20th, or was it okay to start May 1st?
In order for the forgiveness, you have to start your 8 weeks from the date you received the money, not the date you brought your employees back.
So you have 8 weeks. I just want to make sure I get this answer correct.
Yeah.
You have 8 weeks to sunset 75% of the monies towards payroll.
It's
after, and that 8 weeks starts after you receive the monies, correct?
Yeah, the 8 weeks begins the date you receive the money, and you can use up to, and you can, it depends what you want to use it for. You get forgiveness of the whole amount on payroll, but you only can use up to 25% on non-payroll during that 8 week time period for that to be forgiven.
Thank you. Next question. I have a seasonal business operating for 4 months, May through August. I've received my funding, and I've since heard that seasonal businesses can select any 12-week period between May 1st and September 15th to calculate the loan amount. Previously, seasonal operators had to calculate their average payroll from one of two 12-week time periods, February 15th to June 15th, or March 1st through June 30th. This drastically changes the loan. Am I able to amend the original loan amount?
I don't know the answer to that. If you can actually go in and reapply and try to change the loan amount, I don't know the answer to that.
Okay. That's a good question.
That is a good question.
Yeah. We will absolutely follow up with the individuals that ask these questions. So if we're unable to ask a question like this, which is very unique, we will absolutely reach out to you and give you a correct resource or a correct answer.
And I can look into it for you, Mike, and get you some information too.
Thank you so much.
I never had looked at that. Sure.
Appreciate that. Okay. Any other questions coming in? We'll give it another minute or so. And looks like somebody else asked the same question on seasonal business. So yes, we'll reach out to you on an individual basis and get you that answer as well. Okay, with that being said, I think we covered some of this, but please go to Choose Colorado YouTube channel. If you have additional questions, go to startupco@colorado.edu. Next Friday, we'll be skipping the session, if I'm correct, but we'll resume the sessions the following Friday. I would just like to part with a couple of words. I know this is difficult for everybody, and things have been very, very challenging, both on the public health, the concern around public health, but as well as the concern and growing concern around economic recovery. And the sentiment of we're all in this together is really starting to be strained. What I can say is that everybody is still dealing with the same thing, even though people's experiences are a little bit different. We are still all dealing with the challenges, and I would just encourage everybody to walk a mile in somebody else's shoes and have some compassion around everybody's opinion because the strains and stresses are personal, and we need to honor everybody's opinion. I'm very inspired by a lot of the goodwill and the silver linings that we're seeing of people coming together, doing what they can, and helping each other as community, as neighbors. And so with that, I thank you for attending, and we look forward to seeing you in 2 weeks.